In this video, we are going to discuss the test for the removing of parental responsibility from an unmarried father. Within a court proceedings, the mother applied for an order under Section 4, subsection 2A, Children Act 1989, to remove the father's parental responsibility for all three children. Here are the key takeaways the court must apply when deciding whether to terminate a father's parental responsibility under Section 4, subsection 2A, Children Act 1989. The brief background to the case were that the children have been living with the mother at a confidential address in a European country. The father has parental responsibility for all three children after the court accepted a Swedish parental responsibility agreement, which appears to represent a form of parental responsibility agreement. The local authority supported all of the mother's applications, including the termination of father's parental responsibility, proposed a detailed transition plan for education, healthcare, and handover to Swedish authorities. The father had not used the opportunities for indirect contact and that the children did not want direct contact. The local authority supported indirect contact only via a monitored email address. The mother sought several orders, including the removal of the father's parental responsibility. The father did not attend the hearing. He had not engaged with professionals for some time. He told his lawyer he does not need the help of a lawyer to make any submissions on his behalf. He expressed frustration about delays to schooling and surgery, delays which the judge noted were partly caused by him. The guardian fully supported the mother's applications, confirmed the children were thriving in Sweden, and that the father had not exercised parental responsibility in any meaningful way. The first point the court considered is paramountcy of the children's welfare. The court considered the child's welfare under Section 1, subsection 1, Children Act 1989, as the overriding priority when deciding whether parental responsibility should be removed. The court may use the welfare checklist under Section 1, subsection 3, but it is not required to do so for a parental responsibility termination application. The court also considered the no-order principle. Is it better to make the order than not? The second point considered by the court is that the termination of parental responsibility is exceptional and requires solid grounds. Singer J. in Re P. Terminating Parental Responsibility, reported in 1995 at One Family Law Report from page 1048, emphasized, PR is a laudable status and should not be removed lightly. There is a presumption in favor of parental responsibility continuing. Termination should only occur where the circumstances really do warrant it. The third principle considered by the court is, would parental responsibility be granted now? A key question from CW and SG, Parental Responsibility, Consequential Orders, reported in 2013 in England and Wales. High Court Report Family from page 854 is, if the father did not already have parental responsibility, would the court grant it now? If the answer is no, that is a relevant factor supporting termination. The fourth principle considered by the court is, can the father exercise parental responsibility in a way beneficial to the child? The court must consider whether the father can exercise any aspect of parental responsibility in a way that benefits the child. If not, this weighs strongly in favor of removal. This comes from both the cases of Re P. Terminating Parental Responsibility, reported in 1995, One Family Law Report from page 148, and the second case of CW and SG. Parental Responsibility Consequential Orders, reported in 2013 in England and Wales. High Court Report Family from page 854. The fifth principle considered by the court is the no-rival presumptions. The Court of Appeal clarified in Re D. Withdrawal of Parental Responsibility, reported in 2015 on Family Law Report from page 166 that an unmarried father does not have a special presumption in favor of keeping parental responsibility. The only presumption is the child's welfare. Factors like commitment, attachment, and reasons for involvement may be relevant, but they are not a substitute test. The sixth principle considered by the court was, how is parental responsibility shared or used? From the case of Re W, direct contact reported in 2013, One Family Law Report from page 494, the court states that parental responsibility is not just a tick box, it affects the other parent's ability to make decisions. If parental responsibility is being used or misused to obstruct or control, that is highly relevant. The seventh principle considered by the court was whether a lesser measure than the removal of parental responsibility was appropriate. The court considered whether a less drastic step could protect the child. for example, limiting the need to consult the father or restricting information sharing. But as Levan J. noted in the case of Miss X and Mr. Y reported in 2023, England and Wales High Court from page 370 family that, if parental responsibility is already so hollowed out that it has little meaning, full termination may be proportionate. In summary, the tests the court must be satisfied with to terminate parental responsibility are 1. The child's welfare requires it, paramount consideration. 2. There are solid, exceptional grounds for removal. 3. The father cannot exercise parental responsibility in any beneficial way now or in the foreseeable future. 4. A lesser order would not adequately protect the child or the resident parent. 5. Termination is better for the child than making no order. In this court case, the court relied on the following evidence. The father's failure to provide essential consents, causing delay, primarily caused by the father's failure to provide the necessary consent forms for the child's passport and other processes. A history of serious abuse, including physical violence, including non-fatal strangulation, sexual abuse, coercive and controlling behavior. His non-engagement, hostility, dishonesty, and refusal to consider the children's needs. Professional evidence that the children were thriving in Sweden and that the father posed ongoing emotional risk. The father's parental responsibility was being used to obstruct the mother and impede the children's welfare. Now we turn to the court's decision only on the issue of termination of parental responsibility. The judge concluded that the father is unable and unwilling to exercise parental responsibility in a way that benefits the children. But his involvement is actively harmful, enabling him to obstruct education, healthcare, and nationality processes. Continuing parental responsibility would be the antithesis of the children's welfare interests. Consequently, the court ordered that the father's parental responsibility is removed for all children. The judge noted, this does not prevent the father from applying in future to increase contact under English law. And for some of us who want to more research into these principles, the test was applied by the court in the case of Royal Borough of Windsor and Maidenhead and M, and others reported in 2025 Family Court of England and Wales from page 132. This is a Tinaju Children Law Update. Please let us know what you think about this update in the comments below, and if you have not yet hit the subscribe button and click on the notification button, please do so. I look forward to seeing you in my next video.